Good evening, everybody. Thank you so much for joining the first Survive and Thrive event of 2022. As you know, Middle Temple has put on a series of events over the years, looking at matters outside the law, but impact on our ability to survive and thrive. It's a particular privilege and pleasure that we have Master Dutton CBE QC speaking to us tonight about overcoming adversity in his life. And it's also a particular delight that we have Lent reader David Etherington QC participating, effectively chairing this event. So without further ado, I'll hand over to them, and please keep your devices on mute. If you have any questions, don't hesitate to put them into the chat function. And at the end, there'll be an opportunity for those to be answered. But thank you for attending, and thank you very much indeed. And over to you.
Well, Tim, thank you very much for giving us this talk this evening. As I think you're going to tell everyone, we have known each other for a very, very long period of time, probably too long. And I have always admired you enormously, not only your stellar career, but everything you've done for particularly young members of the bar throughout your time, particularly as leader of the circuit and as chairman of the bar. Barristers are very good at talking about things. You're rather different. You're a doer rather than a talker. And from our time at university onwards, if there was anything that needed to be done, you just got on and did it while the rest of us all faffed around, and life hasn't changed very much over the years. You are an inspiration and have been an inspiration to generations of barristers, particularly in the Keble advocacy course that you founded and ran for many, many years. So without any more ado, over to you.
Well, thank you very much, David. Can I also say a brief word of thanks to Catherine Bygrave and Louise McCulloch for inviting me to give the talk, and of course to David, who has valiantly agreed to chair it. And as he said, I've known him since actually my first day at university over 46 years ago, and he's been a stalwart friend ever since. Can I also say what a good idea it is for practitioners to share experiences which may have created particular stresses upon them during their lives, so as to help other members of the profession to deal with these crises when, as inevitably they will, they strike every one of us in our day-to-day lives. Why give this talk? The first question, which I think should be in your mind, is why should I, an aging, privileged, white male practicing from Fountain Court chambers, have anything at all worthwhile to share on the question of surviving in adversity? Such difficulties as I have been through are, as I'm about to explain, caused by two serious health conditions, which I've had to deal with over a number of years. But I readily accept that I do not have the appalling personal experience which many practitioners have gone through of racial, gender, sexual orientation, or other forms of discrimination, which, although much less prevalent now than 43 years ago, are nevertheless ever present in our professional world and indeed in our daily lives. As to myself, by the 1st of March 1974, shortly after my 17th birthday, I realized that the raging thirst which I'd been experiencing for weeks, coupled with a massive weight loss — I was 6'1" tall, but I weighed barely 70 pounds — it all meant that it was time that I visited the school doctor at the boarding school I was at in the Midlands. The kindly school doctor, after carrying out various tests, informed me that I had diabetes mellitus, now known as type 1 diabetes, and that I needed to be taken urgently to hospital. It turns out that I was so high in my blood sugar, I was lucky not to have been in a deep coma or indeed dead. I was extremely ill. I spent the next 3 weeks in Burton-upon-Trent General Hospital. I wouldn't recommend that you ever visit it, where I learned to give myself insulin injections whilst also trying to work for my A levels, which I was due to sit in May, June of that year. The diabetes consultant who was in charge of my care realized that I needed relative peace and quiet to work for my A levels. So by arrangement, he put me onto an old men's ward where men were walking around carrying urine bottles, having had operations on their prostates or elsewhere for cancer, or in some cases were even more severely ill. In fact, during my 3-week stay, I witnessed a man 2 beds down from me who'd been admitted onto the ward in late stages of dementia, dying during the night. This was also the era of the oil crisis and short staffing in hospitals. And from time to time, the ward sister, quite without authority, I'm sure, would ask me to help out on the ward. For example, moving stroke patients who might be severely ill, completely static, where she had no other pairs of hands around to assist her. Whilst I was waiting for the ambulance to take me to hospital, I realized I was actually quite close to death. I was so thin that sitting down was painful, and I'd cut extra holes in my trouser belt, or else the trousers would fall down. Having been discharged from hospital, I was still woefully underweight, and I spent the Easter holiday back at home in North Yorkshire, trying to regain strength and weight, albeit working on a very strict dietary regime, which meant that to rebuild strength and weight, I was having to take on high quantities of protein, but low carbohydrates, which meant it wasn't at all easy. But the fact that I've been so close to a coma and death did at that age made me reflect upon what little I had to show for my life thus far. The result of all this was that I began to treat every day of my life as if it was my last. And I resolved to pack as much as I could into every single 24 hours in order to get the most out of the gift of life. I had hoped that staff at my school would assist. I'd lost 2 months effectively of school time in the weeks immediately prior to A level. And the arrangement was that the headmaster would write to the examination board and advise them that my performance was likely to have been affected by the fact that I'd been hospitalized for 3 weeks, out of action for 2 months, and was still not restored to health. What I didn't know until after my A-level results had come through was that the headmaster had simply forgotten to do this because he was involved in a school fundraising exercise, and he therefore didn't notify them at all. That taught me 2 things. Do not rely upon others unless and until you know that others have acted in accordance with their promises. And second, it fortified my own belief that if I was to make anything of life, I'd have to do it through my own efforts and without reliance on anyone else. A bit more on the diabetes. For the past 20 years or so, my diabetes has been controlled by my giving myself 5 injections per day of insulin, 2 long-acting ones, 1 in the morning, 1 in the evening, and 3 short-acting, adjusted to suit meal requirements. And I've been finger pricking my blood, roughly 7 blood tests per 24 hours, to enable me to check where I was. In my final year at Oxford, I applied for a Harmsworth Award from this venerable inn. The interview was presided over by a bencher who the following year became the treasurer of the inn. And for those drawing out their history books, it was not Lord Roskill. This bencher looked up at me as I came in for interview and asked this: how the hell do you think you can make it at the bar as an insulin-dependent diabetic? And he followed that offensive question up with the following remark: I don't know any diabetics at the bar. I took the last comment first and said, there are 3,500 practicing barristers at the bar. There must therefore be 35 insulin-dependent diabetics practicing at the bar. And I said this: the fact you don't know may indicate that they are well controlled. As to his first question, I added, I will survive at the bar and I hope thrive, because being an insulin-dependent diabetic requires discipline. I'm afraid, undaunted by how offensive he'd already been, this particular bencher then asked, what? You might turn off the telly at night? At that, I became very close to completely losing my temper. But with a degree of anger, I said, yes, I may turn off the telly, but more important, I won't be tempted by things like too much alcohol. What I didn't then appreciate was that the chairman of this interview panel and the treasurer for the following year of the inn was in fact an alcoholic. He was a functioning alcoholic High Court judge. David will, if you ever ask him, confirm that when he called David and myself to the bar the following year, he was so drunk that he in fact called us to the utter bench. We should have been pleased at such a rapid promotion, but the experience of the interview and his drunkenness on call night have left a lasting impression on me for the whole of my practicing career. To function well as a type 1 diabetic, one must inject the right amount of insulin for the food and exercise which one is taking during the day, and one must balance the glucose in one's blood by taking, until very recently, when scanners came into being, blood tests, so as to maintain the blood sugar between a bracket of 4 millimoles per liter of blood and 7 millimoles per liter of blood. If your blood sugar goes too low, you will suffer hypoglycemia, which leads to confusion, shaking, sweating, and if not stopped, you'll fall into a coma, which requires urgent and rapid infusion of glucose for consciousness to be restored. You might en route also suffer a grand mal or epileptic fit. If the blood sugar goes too high, hyperglycemia, the risks then are that one will suffer glycosuria, a high blood sugar, which will cause you in the short term to urinate frequently, before too long to become very uncomfortable, in due course confused, possibly go into coma, and if this repeats itself during the course of one's life, one is at risk of blindness, kidney disease, heart and blood vessel failure. The type 1 diabetic is therefore permanently trying to maintain his or her life in balance. I'm going to turn now to life at the bar as a young diabetic. I was lucky enough to get a tenancy at the end of my pupillage, and I've been practicing full-time at the bar since 1980. The prejudice shown to me by the interviewing bencher meant that I kept quiet about my medical condition and only informed people if there was a genuine need for them to know. I did inform my clerk, and when I knew solicitors well, I would inform them. But on the whole, I kept quiet about the condition and simply tried to maintain a reasonably healthy life, maintain discipline and so on, so as to do my work to the highest standard I could, and then hope that through hard work and application, a practice would develop. Appearing in court will, as many of you will know, cause your adrenaline levels to increase. If you're a type 1 diabetic, that in turn will cause your blood sugar to rise. The adrenaline triggers a sugar cell reaction, and because you're not producing insulin naturally, your blood sugar goes up. For years, I fought cases where my blood sugar was not only higher than normal, but occasionally, frankly, stratospheric. But I don't think that a high blood sugar impaired my performance in court. And there's only one occasion that I can recall where I asked the judge for a short break for 15 minutes so that I could take some glucose on board when my blood sugar had fallen low during a very long court day. We must now fast forward to 2010. My wife and I were at the opera, and as I applauded a particularly good performance, I realized that my hands were painful, hard. I have a very good London GP, and he diagnosed Dupuitran Syndrome, complimenting me on saying, this derives from the Norman French, who must therefore be your ancestors. The advice was that I should use my hands as much as possible, but I might have to expect operations in due course to enable the tendons which were effectively clogging up to be released. In the old days, you used to have your fingers removed. This was my second medical setback. Hitherto, I drafted at the computer, but increasingly since 2010, I've taken to dictating drafts, perhaps a bit more of that if and when we get to questions. The third medical event was the most serious of all. I began to notice from about 2012 that when I was out running, I was getting slower and slower. I tried to attribute that to my age, 55 then, but over the course of the ensuing 18 months, my balance became affected, it became more and more difficult to walk, and eventually I went to a Harley Street consultant neurologist who sent me off for a series of tests. The tests went on across a period of 2 months, and then I went to see him again on the 5th of August, 2014, and he said, there's some good news. You've got a normal central nervous system. I thought, oh, that's excellent. You've got no tumors in your brain. I thought, oh, marvelous. And then he said, you've got motor neurone disease. I may have asked him what the prognosis was, but he was very keen to tell me whether I'd asked or not. Remember, this is the 5th of August, what he considered the prognosis to be. And he said this, you'll be on a walking stick by Christmas, wheelchair bound by Easter, and dead within 3 years. Fortunately, this frankly absurd consultant has been proved to be wrong. I'm of course now wheelchair bound, but I'm still practicing, albeit I conducted my last witness trial in May of last year, and I now deliberately confine myself to advisory work, consultations, strategic advice, that sort of thing. I was lucky enough, at the behest and support of my wife and daughter, to consult another and more expert neurologist who was utterly skeptical of the initial prognosis. It was, however, necessary with this third diagnosis for me to inform all of my instructing solicitors and all of my colleagues in chambers. I knew that I would become physically and visibly disabled, and that would affect what work I could take on and how clients, both professional and lay, might perceive me. I had begun to inform my solicitors before I'd seen the second consultant, who had told me that no predictions could be made about longevity. Most solicitors reacted extremely well, although one, for whom I was working on a large regulatory case, where the trial was due to last 6 weeks and was still nearly 2 years ahead, asked me somewhat disarmingly, well, you say it's terminal, but how terminal is terminal? And I said to him, well, I've been told 3 years, which gave me 1 year to last the other side of the trial. And to his credit, I think, he kept the case with me and the team which was working with me. I kept him apprised of any relevant medical developments. We fought the trial for 6 weeks in 2016. I was able to cross-examine all bar one witness, and we had, I'm glad to say, a thundering victory. Of course, not all cases are successful. I suffered a major defeat in 2017, but I found, once I'd come to terms with this third and terminal illness, that work, if anything, whilst more stressful because of my weakening muscle state, was actually the more enjoyable because of the sheer satisfaction that can be gained from doing a job well, I hope, in adverse circumstances. I promised that I'd say something about the essential attributes and skills of the advocate. For almost everyone on this call, the requisite attributes and skills are very well known, but my purpose briefly in summarizing both is to relate the impact of serious illness or other forms of adversity, please excuse the dog, upon the attributes and skills necessary for advocacy. I suggest that suffering, whether through a disease or in other ways, may, and in my view, more often than not does, have a beneficial effect on the attributes and skills required for the advocate. Skills, first of all. Between 2000 and 2004, I chaired a Bar Council working party, which for the first time in our profession's history, attempted to define the skills required of an advocate in order to ensure that advocacy teaching took place with proper focus and that assessment, which had not yet been introduced, did likewise. We concluded that 5 skills were essential, and not all of the skills, but the 5 skills are an ability to persuade orally, an ability to persuade by written argument, cogent legal and factual analysis, an ability to develop reasoned arguments, and forensic skills with evidence. Those are the 5 essential skills. As to attributes, I've listed 10 attributes of the barrister or the advocate. First, intelligence. Second, clarity of thinking. Third, independence of mind. Fourth, integrity. Fifth, an ability to work extremely hard. Sixth, a sense of proportion. Seventh, an ability to empathize. Eighth, a sense of humor. 9, perseverance. And 10, good judgment. The 10th may actually be the result of attributes 1 to 9. But for me, those are the 10 attributes of a good advocate. What then is the impact of my illnesses upon these attributes and skills? And what about the opportunities which the diseases have provided? Living with diabetes required me to understand body chemistry, physiology, and to be reasonably competent with mathematical calculations. I took an interest in the disease, and in the early 1980s, the professor of endocrinology at St. Thomas's Hospital, who was my treating doctor, rang me up to say that he had a case about a type 1 diabetic HGV driver where the Department of Transport had simply removed his license because he was a diabetic, type 1 diabetic, on the basis that he might at some point have a hypo, would I be able to help? As a result of that inquiry, I conducted many cases as a young barrister in courts around the country, not just trying to keep HGV licenses for type 1 diabetics, where we were largely successful if they were well controlled, but also dealing with problems created where diabetics had done things under the influence of hypo or hyperglycemia. It was the fact that I was a diabetic which brought me into contact with numerous solicitors, many experts, and which enabled me to gain experience as a very young barrister in cross-examining medical experts of some seniority whom the Department of Transport would wheel out in defense of its own position. These experiences and the people I met led to my drafting the medical problem for the Keble course and the fact that we could draw on diabetes experts from around the UK to take part. All of that derived from these early experiences and from the very fact that I was a diabetic. In one of those cases, the Magistrates' Court refused to overturn the withdrawal of the license, and we brought a case stated in the Divisional Court. It was one of my first public law cases, and in due course, it led to an expanding administrative and public law practice. The judge in the case was one Wolf J., then a junior High Court judge, who overturned the magistrate's decision, directed that they hear the case according to the proper legal tests as to which he'd found in our favor, and the particular driver drove for the rest of his professional life and retired happily, having got his license back. I did other medically related cases concerning diabetes, in particular in the 1980s, where the pharmaceutical companies had introduced a synthetic insulin known as human insulin because it was supposed to mirror what naturally produced human insulin does. Unfortunately, in one very significant respect, it did not. Many diabetics given human insulin had unwarned hypoglycemic attacks. Sometimes these occurred when they might be driving, operating industrial machinery, or in situations of risk or danger, which led to a number of court cases. I happen to know that my clients, supported by expert evidence, were likely to be correct, because I had myself been put on the same insulin, and I'd had severe unwarned hypoglycemic attacks, which gave rise to hallucinations, a belief that I was God and that the world would explode unless I used words repeatedly in every sentence with the letters TH in them. Fortunately for me, I never had such an attack in court or when driving, but I was taken off human insulin, as was the rest of the country, to the great relief of all the diabetics. Type 1 diabetes requires one to have perpetually at the back of one's mind a calculation as to where the blood sugar is, what amount of insulin to inject at the next injection, and where one is likely to be over the next period of minutes and hours. The shock of the diagnosis and the fact that I realized I'd nearly died with nothing to show for it has, I think, made me dogged, determined, and persistent. Indeed, many judges may say far too much of the latter. I must also work as efficiently as possible so as to leave space to deal with the diseases. And in my view, the diabetes has been a positive assistance to the development of such attributes and skills as I have as a barrister. What then of the diagnosis of a terminal disease, motor neurone disease, or MND? The impact of motor neurone disease has been different from diabetes. I have, of course, had to summon considerable amounts of willpower in my day-to-day existence, and I'm now dependent upon the care of my wife and daughter for almost every single day-to-day functioning abilities. I'm artificially ventilated for 10 to 12 of every 24 hours. But with their assistance, I can function using my mind and my voice for as long as it remains for me for the remaining hours of the day. And there are, I'm afraid they'll tell you, far too many days when I'm able to work for the remaining 10 to 12 hours. Motor neurone disease has had a differing impact from the diabetes. I've had to make careful and balanced judgments as to whether I take on work, the nature of the work I take on, and what I tell my clients as the disease progresses. I've adopted a policy of openness, albeit I try always to ensure that the picture which I give to anybody instructing me is limited to first what they need to know for the purposes of the case in question, and second, what will be helpful to enable them to explain fully to the lay client the position I'm in. Prior to being diagnosed with MND, I took on as much work as it was humanly possible for me to undertake, providing it was within my sphere of competence, and provided, of course, I could turn the work around within a requisite or reasonable period of time. But MND has required me to find a much greater degree of trust in others. I impart much more medical information to solicitors and clients than was hitherto the case, and I've had to trust them to make the right judgment. And to that extent, my distrust of others, which stemmed from that first interview, has been ameliorated. It's now 7.5 years since the MND diagnosis, and I'm able to say that there's only been one solicitor who has behaved in an unfair and, in fact, probably unlawful manner. I'm sure you will all know that the Disability Discrimination Act 1995 has become incorporated into the Equality Act 2010, and I am therefore someone for whom authorities must make reasonable adjustments. The solicitor who, in my view, acted improperly had been invited by me and my counsel team to a conference in Chambers about a year before the trial of the case that I'd been working on for about 5.5 years. I'd pleaded it out, I'd found the expert for it, I knew the case inside out. The case was now ready and heading for trial. I had a silk as my first junior and a very able junior silk in Fountain Court. The three of us had worked together on a previous case the year before, a trial that went for several weeks. We considered whether, given the prediction as to my condition, I'd be able to conduct the 5 to 7 week trial in 2019 with the assistance of my counsel team, one of whom, as I said, was a silk. We concluded that with appropriate allocation of our own resources to cross-examination of the opposing expert, something which we had done before for the same client in a different case, that I'd be able to conduct the case to the high standard which I hope I'm able to achieve on every occasion. But when the solicitors arrived for a meeting in Chambers to discuss this question at my invitation, and I'd explained my position and that of the team, supported by my latest medical advice, the solicitor simply turned to me and said, "I'm not prepared to risk this, I'm instructing another silk." She'd made up her mind beforehand and was simply not prepared to tolerate any risk whatsoever. Indeed, she took part, I'd wasted my breath. But I decided to make no protest about the judgment she'd made. I could have challenged what she had done, and I think it was unlawful. However, one should, as a barrister, never end up imposing oneself on a client against the client's wishes, no matter how ill-judged those wishes may be. the working relationship for a long trial would be at risk of being too badly damaged when there are already considerable pressures in play. And in any event, the world at large did not reflect this particular solicitor. It has been sufficiently enlightened and well informed to keep the instructions coming to me, with court work being reduced, as I've said, and advisory work increasing. The core message of all of this is that all adversity, in my view, has somewhere in the pantheon of professional experience some advantage. If nothing else, one is able to maintain a sense of proportion when one has been told that one is terminally ill and a client, whether lay or professional, is moithering on about some particular minor issue in the case. Many young barristers at the commercial bar go into chambers at 6 or 7 a.m., sit at a desk and work all day on whether they should plead estoppel by convention, estoppel by representation, or some other form of estoppel, and if so, how best to formulate it based on the authorities which they will have read, and they emerge at 2 a.m. the next morning, pale and haggard, before starting the process all over again a few hours later. There is a very real risk that if one conducts one practice in this way, and without suffering from adversity and the vicissitudes that life throws at one, one's work as a barrister will become diminished. It won't be possible to cross-examine an intelligent fraudster without having a sufficient experience of life's vicissitudes to know how to get under the skin of the fraudster. Still more so, the expert witness in a difficult case. Of course, one must never permit adversity or illness to prevent one from discharging one's duty with a sufficient degree of competence. In fact, that isn't the test in my view. I go further. One should never permit adversity or illness to prevent one discharging the duty one has to act in the best interests of every client. But there are very few illnesses and very few adversities in life which actually, and with a relatively thick skin, will have that effect. I think that's enough from me. Over to you for any questions.
Thanks very, very much indeed, Tim. And I'm getting a rather strange message on my computer, but I hope you can all hear me. I think it's just, I should put it to one side. I wanted to ask you one question, and then I want to start with a question that Alistair Webster has asked. The question I wanted to ask is this, and it is, in a sense, quite a personal one. I mean, you and I both know that we met very close in time to the time of you having the first diagnosis from the consultant who lacked some of the sympathy one might expect in that situation. I remember it particularly because with you and your wife, we were all over the place, and it was you actually cheering us up for the whole evening, whereas it should have been the other way around. But given with the motor neurone, which is, as you have said, a different situation from type 1 diabetes, some people would have said, well, that's it then. I'm just going to go on a world cruise. I don't want to work anymore. I'm going to retire. I know for a fact over the 6 years you've worked extremely hard, some of the hardest cases that you've done in your career. Why have you gone on doing that and not taken, just simply said, well, that's my working life. I'm going to enjoy myself.
Yes, it's a very good question. I did not become a barrister out of a sense of duty. It's because I enjoy it. And I wanted to continue doing things I enjoy, of which being a barrister is a very important part. Not the only one. I mean, music, reading, theatre, opera, all of those are enjoyable. I'm very suspicious of bucket list people, I'm afraid, because I don't understand how it is that during the course of one's life, the items on a bucket list, which should be crammed into a short space of time, have not been thought about and done before. It tends often to indicate to me that one has got something out of balance. I'm not going to say who. I had a friend who died of a terminal condition, who was storing up for his retirement all of the things he wanted to do. And at the point of diagnosis, thought that his bucket list of things for his retirement was no longer going to be possible. And he died very quickly. And in my view, he died very quickly because he was not thinking that carrying on with the life he already knew was going to be enjoyable. And that's my reason, or the reasons for not going on the bucket list tour.
Thanks, Tim. Alistair Webster's a very interesting question, and says that it's an absolutely compelling account, as a number of people have written in to say. But he asks this interesting question: to what extent do you think that the experience of turning difficulties to one's advantage can be transferred across to social or societal disadvantage?
Let me just take one part of Alistair's question. I'm to do this in two parts. One, let's suppose that one's come from a less privileged background than myself. My father was a school teacher, my mother a nurse, but from a very tough background. I've absolutely no doubt that in the course of a disadvantaged childhood, young children and teenagers have to develop an inner and outer toughness far in excess of anything I had. Social disadvantage in that sense can, I think, undoubtedly give you a core of inner steel. It's not always the case, because you can, having been so cruelly disadvantaged, feel as if you're always having to prove something, and things can go slightly out of kilter. I'm not sure I'd give the same answer for things like sexual discrimination, racial discrimination. You may, where you've been discriminated in those ways, have to develop a very tough hide. But the impact of those kinds of discrimination, in my view, I'm not sure people I know well who've been through those can really turn them to advantage, because you know that individuals have chosen in your own sphere of activity to mistreat you, and they're still there. And no one's doing anything about it. And I'm not sure one can ever rid oneself of that feeling.
Thank you, Tim. Louise has told me that I think she has received a question that, due to my technical deficiencies, has not actually come through to me.
That's okay. It's actually it's come from someone that you know and admire as much as I do. So it's from a lady called Pia Dutton. You may know her well.
I see.
Yes. So what Pia's written actually is something I should have raised. Your experiences, this is what she says, your experiences have been extraordinary. Your example a beacon, and your success in the face of adversity really quite unique. She says with no bias whatsoever. The question is, but what advice do you give to those young members of the bar struggling with adversities currently, perhaps wrongly, seen as rather more pedestrian and ordinary, whether it's burnout or disparity of treatment, perhaps glass ceiling, etc.? How do you advise the young bar to thrive in the face of these adversities?
If I may say so, compliments apart, very good question. There are some adversities, the disparity of treatment, if I can just pick on that, where it may be necessary not just to tough it out, but actually to address it, even when you're very young, and know and trust that when you do address it, you take steps to speak to someone, such as a head of chambers, it's not going to make matters worse for you than better. I don't myself believe that we've yet got to the position where, for example, hidden forms of sex discrimination, by that I mean allocation of work as between men and women, for example. I know I did work on this when I was head of Founding Court. I know that the commercial world instructs women less the harder the cases get. Now that's an issue which one has to address, and which as a young practitioner, one can begin to feel very keenly. How do you deal with it? First of all, you've got to say to the clerk, I need more work. I'm concerned that I'm not getting it. And possibly say, look, I'm seeing male members of chambers getting this work, that sort of thing. Or go to the head of chambers or head of diversity. You may decide to tough these out so as to not actually do as you will fear, make the position worse. I think that judgment is a really difficult one to make, but the absolute minimum is to talk to someone in confidence whom you trust for the advice as to which direction you take. Bottling it up and doing nothing and saying nothing will get you nowhere. And then the last point I want to make is one does have to develop a very thick skin. Over my period at the bar, there have been some outrageous judges. They're much fewer now, who were deeply offensive in open court. We've all had that experience, and one simply can do very little about it, but fight on the next case, take the case to the Court of Appeal, and just do one's absolute damnedest never to fall below a high standard.
We've had a question from a very young and inexperienced member of the bar, who I think, if I get her name right, Maura McGowan, and she wants to ask a question. Actually, I'm very interested in the answer to this. Given your natural and acquired advocacy skills, she says, why not crime?
Maura knows part of the answer to this. By the way, Maura's a member of the bench. So I did do crime for the first 6 years of practice. Certainly more than 100 jury trials. I was doing 30 jury trials a year, short trials, in that period. And I found it really helpful to develop advocacy. My reason for concentrating on commercial civil work, and then as things developed, public administration, public administrative law, and so on, was that I wanted more variety in the legal challenges in the work I did. I still wanted to practice advocacy, and indeed I've generally been doing trials all the way through, but I wanted it to be where I wasn't representing defendants who came up with it wasn't me, I didn't intend it, what I thought of as the criminal defenses. At my time of life, Maura, it wasn't money. In other words, I made a choice to specialize away from crime. Sadly, though, now I think the financial problems facing the criminal bar are so severe that leaving the criminal bar in order to keep a family afloat seems to me to be a choice many people find they have to make.
I will get used to this. Tim, I just want to ask you one question, which relates to something you yourself said you would come back to, and that's the topic of alteration of working practices because of a disability. And so possibly the least of all your worries in your life, but probably quite painful, your hand issue that you had caused you to turn to dictation. I've often found dictation actually quite difficult. I thought it would be really good, really easy, because I talk a lot, and in fact found it quite difficult. What was it you wanted to say to us about dictating?
Yes, I wanted to share the experience. When you dictate a draft, it has to be as if you're writing with your hand in economical forms of expression. And it's mastering that is the issue. And the way one has to do it is to have, often in a note form, and I can use my hands enough for that, or at least very carefully in one's head, precisely the structure that one's going to work to. It's very different from oral advocacy, as we know from drafting opinions and drafting skeleton arguments. And then the system I've got is that as a disabled lady, it just so happens, who sits in Sheffield, and when I dictate, it goes onto my computer and onto her computer. She sends the draft back, and I could then either dictate adjustments and amendments to it, or my hands are sufficiently good still for me to refine it. You must always edit whatever you said orally so that the draft is sufficiently concise and carefully woven together. The other reason for coming back to it is I will eventually lose my voice. I'm very lucky as an MND sufferer that, touch wood, the voice is hanging on in there. When that goes, then I've got to find another means of communication.
Well, Tim, thank you very much for the talk, for inspiring us all. I haven't read out all the many messages from people who've been watching, who have made that comment in one form or another, talking about how amazing and inspirational it's been to listen to you. I would also, I know both of us, both you and I, Tim, would like to thank the Inn for everything they've done to allow this to take place. And to our treasurer, Maura McGowan, to give her her proper title. Those are the questions that have been asked. Is there anything you'd like to say in conclusion?
I'll end with something lighthearted. In 2015, we all go to those Chambers Awards, and Chambers gave me an award, a Lifetime Achievement Award, which they normally give when you're about to keel over. And I ended my speech by saying, I described the 3 conditions and what it all meant. And I ended my speech saying, if you want to get on anywhere at the bar, for God's sake, get a diagnosis. I think I'll end on that note.
Thank you very much, Tim. So, Louise, I will hand back to you for any concluding remarks.
Just to thank you so very much, just to add to the chorus of thanks for totally inspiring speech. It's energizing. Thank you so very much. Yeah, please, just thank you. I don't know what else to say. I haven't really written anything down after this. So Master Readers Feast is on the, I think, is it the 15th of February? Tuesday the 15th. So if you want to sign up for that, that would be splendid. But Tim, thank you so much for what's been a really wonderful evening.
Pleasure.
See you soon.
Bye-bye, everybody.
Bye, everyone.